arguments by mine before I deal with the arguments by the government. So, firstly, they, on the interpretation argument, proceed from what they claim to be the policy context. But it's not the policy underpinning PILRA. It is what they claim to be the policy context at the time of the coming into effect of the PILRA. At that point, your leadership can see the basic flaw in the argument. You are now required to go and excavate policy discussions of the government at the time it enacted the PILRA. But that is not how statutory interpretation works. One takes the legislation as the expression of the will of the legislature. So the starting point is always the statute itself. One does not seek to try and find out what was thought by parliamentarians. One seeks to establish what the purpose of the legislation as discerned from the contents of the legislation itself. One can imagine how dangerous the exercise can be if one started trying to second guess what the executive thought or what the legislature thought at the time it enacted the legislation. So there is a basic flaw in asking your leadership to look at the RDP document and to look at the white paper. The only policy that is germane in this case is the policy post the passing of the legislation, because it is binding government policy. Yesterday, I undertook to make reference to the ETV case. I have a copy for your leadership. If I may hand it up. Could go to paragraph 30. Of that judgment. And this is the judgment by Chief Justice Mukwena, talking about the significance of post-legislation policy. Because paragraph 30, my name.
Yes, that's the one I'm missing.
I know, it's copied on both sides. Yes. But if you look at paragraph 30, this is where, in that context, the minister passed a policy on how she would implement a particular legislation under the Electronic Communications Act. And we have stated, and this is again an undisputed point, that the policy of IPILRA was endorsed specifically by the minister. Chief Justice said, national policy is not inconsequential. If it were, the Constitution would not have made express provision for it. It is intended to be an essential governance and service delivery enabling tool in the hands of the executive. And broadly speaking, policy is supposed to be a compendium of guidelines or principles on which decisions for the execution of an institution's mandate or vision are to be based. It essentially ought to give direction or point to the course of action to be followed. As is the case with all other national policies, Minister Rutambo must have intended hers to be taken seriously by agencies and all other functionaries who needed guidance or direction on broadcasting digital migration. So we know that government policy about how it intends applying particular legislation is of significance. Chief Justice Mukwena sources it directly from Section 85 of the Constitution. Although there was a dispute about that point in the minority judgment, but the fact is that Chief Justice Mukwena's judgment was the majority judgment. The policy on IPILRA, which starts at page 451, makes the position clear. At page 453, paragraph 3.5, about what rights exactly are protected by IPILRA, despite what my learned friend says about the implications of IPILRA. 3.5. The Interim Protection of Informal Land Rights Act confers certain rights on people who occupy land on a customary basis in the former homelands in SADT areas. In terms of this act, such people may not be deprived of an informal right to land without their consent, except by expropriation. Nothing could be clearer. What the policy of the state is, which according to the Chief Justice, is not an inconsequential instrument. It is an instrument that was designed to be binding. It is an instrument that is perceived by the recipients as binding. It is quite clear that as far as the land is concerned, there can be no deprivation except with the consent. The only instance where a deprivation would be allowed without consent is expropriation. The second point that my learned friend makes, which again illustrates another flaw in the argument, is the distinction that he tries to draw between formal and informal. And what he tries to suggest is that we should understand IPIRA as no more than a formalization of informal rights on an interim basis, pending long-term legislation. But he is wrong in that, because IPIRA protects specifically customary law. He has not pointed to a single statute that protects customary law rights over land. It is the only statute. And hence, when he criticizes us for focusing on the customary law aspects of IPIRA, he has no basis from Section 1 and Section 2 of IPIRA, because Section 1A makes the position quite clear that embedded in the definition of informal land rights is land held on a customary basis. So IPIRA is part intended to give effect to customary law. This is not a comparison between formal and informal. It is a recognition of prior existing customary law rights. We have taken your leadership through the authorities from the Constitutional Court, Alexco, Maelane, Bear, that make the position clear that customary law is an independent source of rights that are recognized by the Constitution. So, what does this mean? Two aspects. First, because IPIRA gives effect to customary rights, it has independent constitutional standing, and that flows from Section 211 and Section 212 of the Constitution that expressly recognize customary law. What IPIRA does is to govern customary law in the context of land. So it recognizes a constitutional entitlement to customary law rights over land.
These holders of informal rights customary law are now given special recognition.
Yes.
In other words, one could almost say that there are three categories.
Yes.
Informal, formal, and then the informal customary law rights.
Precisely. They are. The second aspect of the argument goes beyond the status of these rights as customary in nature. And we have gone through this and we have shown your leadership why customary law on its own is important and deserving of recognition. But there is another reason, which is the Bill of Rights. What we have shown to your leadership is that IPIRA, and again, this is not a point that has been contested, IPIRA gives effect to Section 25(6) of the Constitution. In other words, it gives effect to a right protected in the Bill of Rights. There should be very limited circumstances where a right in the Bill of Rights should be invaded those limited circumstances are specifically provided for in Section 36 of the Constitution. But they must be specific. So what we see from IPILRA are these three elements that I'm trying to illustrate. First is a statutory recognition of informal land rights. Second is an express recognition of rights based in custom, which has its source in Section 211. Third, IPILRA gives effect to Section 25(6) of the Constitution. Once we can now see, then the language of special protection actually loses relevance completely. Because what we are talking about is rights protected directly by the Constitution, either as part of the customary law or as part and parcel of the Section 25(6) rights held by the communities. Any invasion of those rights would require an express legislative decision. The MPRDA is not one of those. And therefore, IPILRA is an important piece of legislation from a historical perspective, but also from a contemporaneous perspective, because IPILRA gives effect to something that we've never seen in this country, a constitutional recognition, customary law rights to land, and it gives effect to Section 25(6) of the Constitution. So, from that point of view, we can see that the underplaying of the rights that the mine attempts by simply comparing it to formal rights actually makes no sense in the constitutional context. So the second point that they then make is the question of what they call the legal context. But what this legal context boils down to, what they want your leadership to do is that you must go and excavate from the dustbins of history the Minerals Act of 1991. It is an apartheid-era legislation. They want you to draw the source of post-constitutional legislation from an apartheid-era legislation. That is not only regrettable, but it stands to be rejected. One cannot start off in trying to interpret my client's rights under IPILRA and, in fact, the MPRDA by reference to apartheid-era legislation. The point is made repeatedly at the Constitutional Court, including in the cases like Makate, about the necessity of judges being aware that the starting point is the Constitution, and where the legislation has been expressly repealed, the correct starting point is what the government did yesterday, which is to focus on the MPRDA. So my learned friends' starting point by reference to the Minerals Act of 1991 is a regrettable starting point. But nevertheless, it is also mistaken on the law. Why? Because he claims that we were never holders of informal rights to the minerals under the Minerals Act, but we have never asserted being holders of informal rights to minerals, nor have we asserted any form of rights holding to minerals. Why? Because everybody accepts that the implication of the MPRDA is to restore or allocate custodianship of minerals to the state. What the case has always been about has been informal rights to the land. This is what the case is about. And that is why your leadership can take a red pen and strike through the entire argument based on the Minerals Act, because its premise is fundamentally flawed. It focuses on something that the case is not about, on whether or not we had informal rights to the minerals, when the case is about informal rights to the land. Those rights are now statutorily protected by IPILRA. What he then says in building up this fraud argument is that because an owner of the land never had a right to prevent mining, we can therefore not assert an entitlement to prevent mining. But my lady, this is precisely not what the case is about. This case is about whether or not under IPILRA community consent is required. One of the things that would have struck your ladyship in the arguments yesterday by my learned friend from the state and today's argument is how there has simply been no reference to Section 2.1 of IPILRA, because the text of IPILRA is clear. No one may be deprived of an informal right to the land without their consent. And they are stuck with the point, because it is not as if the rights of IPILRA have been recognized in the abstract. The government has chosen a particular mechanism of protecting those rights, that they must be with consent.
Just one point that you might clarify. Yesterday, Council on behalf of the state made the point, as I understand, that one has to make a distinction where the mining rights granted, that doesn't constitute a deprivation.
Yes.
I'll show you the video, but then you made the point, it's only when you start accessing the land, that is where the deprivation starts. What should I make of that argument?
Yes, I will come with that when I deal with the state's argument. There is, the summary is that there is no substance to the argument because it fails to distinguish between a legal deprivation and a physical deprivation. The legal deprivation takes place at the time the right is awarded. Of course, when the excavators and the trucks arrive, that too is an extension of the deprivation. And that is presumably why the mine didn't take the argument. In fact, in the argument submitted yesterday, if I have permission to just carry on, yes. Could I then move on to what the state suggested yesterday? So the first point that they proposed was the questions of fact, that they suggested that there are certain facts that they have not dealt with. Those will be dealt with in due course. We don't fully grasp the significance of that submission because the full facts that are relevant to your ladyship's determination are before your ladyship. And your ladyship knows the principle, plus one Evans applies. If facts have not been denied, they have not been denied. The state must live according to the consequences of their election. But also, the facts around the custom, because custom is now embedded in IPILRA, are set out in the papers, and the state must live according to those facts. If they decided not to deal with those facts, they must live according to their election. So we would suggest that both according to the plus one Evans rule and according to the authorities that we've cited in paragraphs 236 and 239 in relation to the principles of customary law, they are simply bound by the election that they made not to answer the facts that we have pleaded. And if we just look at where the state left us, we just take stock of what the state left us. Firstly, no dispute around the account of customary law and its legal status embodied in section 211 and 212 of the Constitution. Secondly, no dispute about the application of IPILRA in relation to the land that we currently occupy. And on that score, no dispute about the fact that IPILRA gives effect to section 25(6) of the Constitution. Thirdly, no dispute about international law as a distinct source of rights and obligations, and specifically guaranteed by section 39(1) of the Constitution. Fourthly, no dispute about state policy. What is the common thread running through all of these instruments is that if you are going to infringe the rights of communities living in land that is protected by IPILRA, you can only do so with their consent. If you are going to infringe their use, access, and occupation, you can only do so with consent. What they then suggest are these two arguments. The first argument being there is no deprivation at the time of the granting of the right. The problem, of course, as I have already suggested to your ladyship, is that the argument doesn't draw a distinction between a legal deprivation and a physical deprivation. What we are dealing with here is that as a matter of law, there has been a deprivation. And if your ladyship can have regard to the, and I'm now using the authorities bundle of the mining company, but if your ladyship has regard to the judgment of the Constitutional Court in Agri SA, and it's at page 52 of their bundle of authorities. and particularly paragraph 53. This was a debate about whether or not the passing of the legislation had the effect of the deprivation, or whether or not the deprivation amounted to expropriation. But this is what is held at paragraph 53. It follows that the MPRDA, which is a law of general application, had the effect of depriving Sebenza and a similarly positioned holder of a pre-existing mineral right of elements of that right as correctly considered by the minister. It is common cause between the parties that the deprivation was not arbitrary, and this is correct considering both the objects of the MPRDA and the transitional arrangements. Did this deprivation rise to the level of expropriation? The key point to be made about this passage is that the passing of the Act had the legal effect of deprivation, not of the actual physical asset, but a deprivation of a right in the property. So what we are dealing with here is that our rights to the land will be deprived by the grant of a mineral. And so that is quite clear that the mere fact that the right is granted will result in a legal deprivation of a right that we have over the land. And that is why we are entitled to come to court and ask for declaratory relief, because our rights are at stake. It would not make much sense, sorry.
So, in other words, is it sufficient then, the granting, when the Act was passed, we don't know why the reasons for the Act. We all know what those reasons are. But the effect of the Act is to deprive everyone in South Africa of the mineral rights. I think we'll actually then on that.
Yes.
So I'm still struggling with the concept, and I understand your arguments in respect to customary law. But it's the only reason why they are recognized as separate categories because of the status granted to them in terms of the law.
Yes. The declaration that we have sought here in paragraphs.
So all other individuals or communities who occupy a land informally,
Yes.
unless they are recognized as a customary community, if I can put it that way, they don't have the right to refuse mining on their land. Is that the impact of this commission?
No, your leadership does not have to decide that point. Your leadership is confined to paragraph 1 by the impact of IPILRA. So what we will ask for in paragraph 1 is that those communities where IPILRA applies, because IPILRA is the only statute that guarantees consent. So where IPILRA applies, then paragraph 1 and 2 of the notice of motion would then be the consequence of it. The other communities where IPILRA does not apply, we have no way of knowing whether or not those communities have informal rights, because the only statute that guarantees informal rights is IPILRA.
The issue of consent, we know that in terms of the NPRDA, the right to refuse, in other words, the right to sterilise land has now been taken away, we understand that. But it would appear that if the court accepts your argument, the court would implicitly accept that, if I could put it that way, customary communities, they still have the right, they still retain the right to sterilise the land. I'm not saying they are not, but the principle is that they still retain the right.
No, my lady. Your leadership does not have to go that far for the purposes of the declaratory order that I see, because on a factual level, the issue is actually canvassed and it is not in dispute. This is what my clients say about the issue. This is, if your leadership looks at 117, 118, 119 of the founding affidavit, yes, and then earlier 103, 104, 105, 106 of the founding affidavit. This is what they say. They say that there is a system applicable within their community, and that system is a system of decision-making. And they explain how that system of decision-making applies, and that is a customary decision-making system. And they explain precisely how decisions ought to be made in relation to the allocation of land. And you will see at paragraph 106, where they specifically deal with this. This does, of course, not mean that it is not possible to approve mining on community land. This is the point. So the right that we have come, and they explain why they say that is so in paragraph 106. So the right that we have come to contend for is the right to participate meaningfully, including the right to consent over the land. And this does not mean that consent will never be given. And if your leadership looks at the facts that we dealt with yesterday, especially the facts around how the company has kept my clients in the dark about what its plans are in relation to the mine, especially the facts about how the company effectively made improper overtures to the current community leader, the chief of the area.
If this were not a part issue of consent,
yes,
and just concentrate on the argument that was, and that is that has been listed in the law.
yes.
Isn't that an issue that becomes pertinent when one reviews the decision of the minister to plant in Amadiba? In other words, that is when that comes into play, because one of the reasons that would be advances, we have not been able to consulted, therefore the decision of the minister becomes reviewable.
Yes, it becomes relevant at that level, I accept that. But it is relevant also for purposes of the declaratory order. Because the leadership will know that this is a declaratory order about the quality of the information that my clients should have prior to exercising their consent. Yesterday we went through the principles of international law, free, prior, informed consent. So in exercising their right to consent, it is a relevant factor that the mine has kept them in the dark. On the common cause facts, it has kept them in the dark. And it has made improper overtures to its local chief. That's the first reason why, on a factual level, there is no sterilization. But on a legal level, there is no sterilization too, for two reasons. The first is section 55 of the MPRDA itself. This is what it provides. Ministers have power to expropriate property for purpose of prospecting or mining. If it is necessary for the achievement of the objects referred to in sections it goes on, the minister may, in accordance with section 25(2) of the Constitution, expropriate any land or any right therein and pay compensation in respect thereof. So they have a statutory right not to demand our consent if we are unreasonable in withholding it. They have a right to expropriate the property. But of course they know that the right to expropriate comes with it the obligations that are imposed by the Expropriation Act and the obligations imposed by the Constitution. But apart from the MPRDA, if your leadership has regard to IPIRA itself, IPIRA's provisions in section 2, dealing with deprivation of informal rights to land, subject to the provisions of subsection 4 and the provisions of the Expropriation Act of 1975, or any other law which provides for the expropriation of land or rights in land, no person may be deprived of any informal right to land without his or her consent. Both of these provisions, our rights to IPIRA, are completely overridden by the Expropriation Act because it's built into section 2. Even the requirement to consent is subject to the Expropriation Act. The MPRDA itself contains section 55, which entitles the government to expropriate the land. So there is in fact no purchase at all to the supposed argument about sterilization, because on a factual level, we explain that the nature of this consultation, where we are not required to give our consent, is perfunctory. But this does not mean the community will never consent to it, and they make it clear what the preconditions for their consent might be. But forget about the community and its decision-making, and there may be cranks and recalcitrant within the community who may be unreasonable. The state has an embedded power in Section 55. It gave itself the power. It gave itself the power even under appeal. So we are not really dealing here with a question of consent as such on this part of the debate. We are dealing with the failure by the state to exercise a power that it has directly under the Constitution if it feels that we are dragging the process out and we are being unreasonable in refusing our consent. So there is no stage at which it might be possible for my clients and your ladyship's declarator. Your ladyship grants us the declarator in 1 and 2. That declarator will not lead to a sterilization because it will be a declarator that itself is subject to Section 2.1 of IPILRA. And Section 2.1 of IPILRA gives the state carte blanche authority to expropriate the land so that it can carry on with the mining. But we don't want to speculate around why the state does not want to expropriate, because we expressly pleaded the point. And we are where we are. So that shows your leadership that there is no sterilization. Let them move on.
So, just one addition. What is the applicant's submission to the interaction between now 20 section 1, 2b? That is where it says the holder of the informal right of land shall be deemed to be an owner of land for purposes of section 42 of the Mineral Act. Now, we know that section 42 refers to compensation in respect of agricultural land.
Yes.
Why did IPILRA include this section if it's implicit in this act that consent must be granted before a mineral right can be awarded?
Yes, but the Section 54, though, that I think our learner friends were referring to, which they say, because Section 42 is one, Section 54 is the right to compensation.
Yes.
And there is no dispute as far as we are concerned around their entitlement to compensation. What this dispute is about, the current dispute is about, is when should that compensation be paid? And that's the alternative argument that was made by Mr. Spoor yesterday. So on the compensation, it's quite clear what the rules are. That for purposes of determining who is entitled to compensation, the holder of the informal right is deemed to be the owner. And that's in order to determine who should be paid the compensation. But that has no relevance to whether or not, for purposes of use, occupation, and access, which are the three core informal rights that are protected by IPILRA. For that purpose, whether you are entitled to consent, that is a question about what should happen to compensation under Section 54. So we don't see the distinction that our learned friends are drawing in the greatest of respect, because our Section 1A rights are not affected by the mere fact that we are deemed to be owners for the purposes of determining compensation, because that simply determines who is entitled to compensation. But it does not determine even the nature of the consultation, nor does it determine our substantive rights to consent before the mining operations can carry on, or before the Section 23 rights can be exercised. So we must respectfully submit that the determination of compensation does not stand in the way of working out whether or not consent is required for use, access, and participation. And so Mr. Spoor's submissions yesterday were not in conflict with Section 42, Section 54. What his submissions said is when should that compensation be paid? And he suggested yesterday that that compensation ought to be paid prior to the granting of the right under Section 23 on a holistic constitutional construction of the section. So one cannot, with respect, oust the requirement of consent by reading into it the entitlement to compensation, because those clearly govern two separate issues. The entitlement to compensation can exist side by side with the entitlement to consent. Could I then move to the third issue around the interpretation? Your leadership will remember that we were taken through the text of section 23, and there was a reference to 23(2)A yesterday as the two key provisions of the MPRDA that entitled the state to effectively act without consent. Three problems arise with that construction. The first is we now know that any interpretation that would entitle the state to act without consent will violate the PILRA, it will violate customary law, it will violate international law, and indeed, it will violate section 30 and section 31 of the Constitution. Those are independent entitlements. And we know those violations will occur in the context where there has been no assessment whatsoever of the nature and the degree to which the rights can be invaded or infringed or taken away by a way of a statutory interpretation. a statutory enactment. The second problem concerns the principles, and my learned friend for the mine has dealt with the principles of statutory interpretation. I want to refer to two additional judgments which are cited in page 16 and 17 of our heads of argument. The first one, we refer to this in paragraph 36. And it's a judgment of Mark Caruso Vodacom. This is what it says. The guiding light of interpreting statutes in section 39(2) of the Constitution, which requires that courts interpreting any legislation must promote the spirit, purport, and object of the Bill of Rights. As the Constitutional Court put it in Mark Caruso Vodacom, section 39 means courts are bound to read a legislative provision through the prism of the Constitution. The obligation is activated whenever the provision under construction implicates or affects rights in the Bill of Rights. So there is an independent obligation flowing from section 39(2) of the Constitution that if an enactment implicates constitutional rights, there is an obligation to read it through the prism of the Constitution. There is a cluster of 3 rights that are at issue: section 30, section 31, and indeed section 25(6) of the Constitution. So whatever construction is given to the MPRDA, it should be a construction that is restrictive, limited in relation to its impact on existing constitutional rights. That is emphasized in paragraph 39 of our heads of argument, where we say, at the same time, section 39(2) specifically, and the Constitution as a whole, embraces a new approach to interpretation. It requires courts to prefer a generous construction over a merely textual or legalistic one, in order to afford the claimants the fullest possible protection of their constitutional guarantees. So we have these 2 obligations, and there we've referred to the Ngcukaitobi judgment. We have these 2 independent obligations flowing from section 39. The first is to construe statutes through the prism of the Constitution. The second is to ensure that when statutes are construed, one goes beyond textualism and looks at a construction that will allow claimants their fullest possible protection of constitutional guarantees. We can compare this with the arguments that have been advanced what we have been told is that the minister can ram through our informal rights that are constitutionally guaranteed. Ram through the informal rights, and the mining company can tomorrow set up its bulldozers in our land. Those constructions to the MPRDA, Section 23, are completely in conflict with Section 39(2), obligations of the court. So we would suggest, with the greatest of respect, insofar as the MPRDA is an embodiment, sorry, not the MPRDA, the IPILRA is an embodiment of our rights to Section 25(6), those should be expanded, given the fullest possible construction. Insofar as the MPRDA's construction impacts negatively on those rights, it should be interpreted restrictively. This is the mode of constitutional interpretation that we are advancing. This is why we suggest, actually, if you adopt the approach of restricting the power of the state where it will infringe rights and expanding rights which are guaranteed by the Constitution, there is in fact no conflict. In fact, the two are completely reconcilable. Because where we end up with listening to the state and listening to the mining company, where we end up is that they want the court to find that under Section 23 and the construction that they have interpreted, under that provision, you are entitled as a mining company to infringe informal rights to the land without consent, as they are protected by Section 2(1) of IPILRA. That is the ultimate endpoint. In circumstances, my lady, where the MPRDA, when it wanted to deal with minerals, it expressly put the ownership of minerals in the custodianship of the state, but it never did so in relation to land. In circumstances where you don't have a clear statutory basis for this running through of our rights, what they want ultimately is the minister does not have to get our consent. The mining company can walk in as soon as it gets the minister's permission. They want that approach to be adopted in the face of a clear legislative enactment in the form of IPILRA. And that is why our learned friend for the mine were at pains to try and illustrate that actually IPILRA was short-term, IPILRA had a particular policy basis, IPILRA was informed by the white paper. The ultimate point that they want the court to accept is that they are entitled to infringe IPILRA. That, we say, is in conflict with the correct approach to constitutional interpretation that is endorsed by Section 39. The final point around interpretation, to expand on what my learned friend for the mine suggested, when he spoke about context, is historical context. We have referred to this issue about historical context in paragraph 41 of our heads of argument. And specifically the judgment of Daniels versus Scribante, the Constitutional Court. And the point probably is self-evident. Statutes must be interpreted in a way that corrects the historical disparities, the historical distortions, so that the animating theme of the constitutional project, which is the Never Again project, is not replicated under the current conditions. And this is the point made by the Constitutional Court judgment of Madanga J in this Daniels and Scribante judgment. What is a historically correct construction of IPILRA? The historically correct construction of IPILRA is this was an attempt at the restoration of rights flowing from custom that were undermined under the previous dispensation. But it is not a restoration in an abstract way. It's a restoration because it is connected to the dignity of the applicants. And this is why this passage is absolutely vital, the passage we cited, which is paragraph 23 of Daniels versus Privanti. So we suggest to your leadership that one cannot adopt an interpretation that promotes the undermining of rights in circumstances where those rights were conferred as a measure of restoring past disparities. So, in conclusion, we say that the MPRDA in section 23 does not oust the provisions of IPILRA. In section 23 sub 6, which is the same provision that was referred to in Maxat, it specifically says that the exercise of a mining right must take place in the context of other legislation. And this principle was given effect in Maxat when the Constitutional Court found that your section 23 rights does not oust the operation of a municipal ordinance. We say that section 23 to capital A is again not an ouster to IPILRA. What it does is exactly the same purpose of section 22. What it does is to create a special layer of protections for communities under the MPRDA. But what it doesn't do, and this is why the state's argument is flawed on this aspect, what it doesn't do, it does not define the ceiling, the full extent of the protection. It simply imposes in the MPRDA the requirement to consult with communities, but it does not deal with the obligations imposed by IPILRA. And again, it's not an ouster to IPILRA. It's not a license to the government to infringe its IPILRA obligations. So we say that the MPRDA must be read consistently with IPILRA. Section 23 of IPILRA, it does in fact contemplate, in 23.6, does contemplate the application of other statutes. And the practical effect of that we have already seen in the Maxant judgment, where the very same argument was raised. Once you comply with section 23, that is the end of the debate. And the Constitutional Court says that is not the end of the debate. Then, so we've made the first point. Comply with IPILRA. You should not infringe section 25.6. You should respect customary law. And you should therefore reject the textualist approach that the state has advanced. Because, I mean, the state refers to concepts like must, and therefore it's an obligation. But of course, that is true. It is an obligation imposed by section 23. But it is in the same way as section 23.6 must be read together with other statutes such as the Lupo Ordinance, the Water Act, the National Environmental Act, and other statutes. Then, my lady, to round off the points we have been debating around the question of remedy, your leadership knows that the remedy that we seek is a declaration that when the minister considers and approves section 23, he obviously must take into account the consent by the community. And if there is no consent for the community, then he has no power to approve. There are two ways of reading that obligation. If we are right in the substantive argument that IPILRA requires consent where there will be an interference with use, occupation, and access. If we are right, there are two ways of giving what is called under the Constitution a just and equitable remedy. The one, which is what we prefer, is to make that declaration upfront so that you save everybody the trouble of going through the motions of section 23 and then being forced to come back to court after the license has been granted. The time is right now because the facts are known, the answers by the government are known, and most importantly, the legal arguments have crystallized. So it seems just and equitable to impose the obligation at the time of the consideration of the mining right. The alternative, which is what the state appears to argue, is to allow the state to grant a mining right on the basis that your imperial rights have not yet matured to the point of enforcement, and they might mature at the time the tracts arrive. But that will not be a just and equitable remedy, because it will postpone the dispute to a future uncertain date. But not only will it postpone the dispute, it will simply create conditions of conflict, because it is impossible to see practically how my clients are required to respond to a situation which is not unlikely in the light of the background history sketched in these papers. How my clients are likely to respond to the arrival of the excavation trucks on their land because the Section 23 right has been granted and the question of consent has been postponed to a future date, to wait until, according to the state, the actual deprivation takes place. In other words, the physical displacement takes place. We say that approach is not a just and equitable approach because of the two consequences that it will bring about, which is the postponement of the dispute which has crystallized, and secondly, the likely germination of conflict within the community. It is the responsibility of the court to make the determination now whether or not the consent is required, rather than waiting later. We say that on the substantive grounds, there is no reason why we should be deprived of the order that we seek in paragraph 1 and 2. And certainly there is no reason why that dispute should not be decided today, and it should be decided at a later stage. What then that addresses is this question of when the deprivation occurs. And I've tried to suggest to your ladyship that the legal deprivation has occurred at the time, and therefore, on the merits of the case, your ladyship is entitled to make that decision now. But I'm making a submission on remedy, on the assumption that your ladyship is unsure whether or not the deprivation has occurred. As a question of just and equitable remedy under Section 172, it's just and equitable to make the declaration now. There is, of course, a third alternative that your ladyship may consider to be just and equitable, which is precisely what happened in McNexon versus Lupo, is that if your ladyship is satisfied that under IPILRA, we are entitled to consent where there will be access, use, and usage which is infringed, which is that declaration can be made that under IPILRA, my clients are entitled to consent. But that still leaves the problem as to whether or not the mining rights granted under Section 23 can be executed without consent. And that takes your ladyship beyond the dispute that we have had in these past 2 days, which is the dispute around whether a Section 23 permit can be granted, but into a different dispute, which is whether a Section 23 permit can be executed without consent. And this was the case in Maxine. That is an option available to your ladyship, but we do not commend that option because its consequences are still not to resolve the dispute between us and the mining company and the government. It's still preferable to make a determination prior to the granting of this, so that everybody's rights can be known upfront. This is precisely why we brought an application for a declaratory relief, because we want a declaration of rights of the government, of the mine, and our client. And although there were initial opposition to the nature of the declaratory relief, the fact is that by yesterday, everybody had accepted the desirability of getting legal certainty to the legal questions. So we would respectfully submit that you should not buy easily into the suggestion by the state that there might be some other future date at which the issue becomes crystallized. The issue has crystallized now, and a judgment is necessary now on the substantive legal questions. What that leaves then is the question of cost. The state is right in relation to the cost between us and the state. It's unclear what the mining company is complaining of, because they say that they asked us not to cite them. But it's impossible not to cite the mining company where you are fighting about their application. So whichever way one looks at it, any judgment that your leadership would have granted is a judgment that would have implicated a fifth respondent. So it's quite self-serving to say that they wanted out of this dispute. And even after the application was brought, they could have stayed out of the dispute. But they decided to oppose fully. And they decided to even go to matters that stray beyond their own limited interests. And they wanted to address declaratory orders on the broad principles of how the application of the MPRDA versus IPIRA intersect. So they first ask not to be cited. Once they are cited, they go into the dispute and they address everything. And then later on, in a self-serving fashion, they say that they should be entitled to cost, even though they understand that in substance, this is constitutional litigation. And it's constitutional litigation of the greatest import brought by a poor community in circumstances where we have shown how disgraceful the mine has behaved. So we would respectfully submit that the same principle should apply in relation to the mine. As the community, if we are successful, we are entitled to the cost. If the mine is successful, they are not entitled to their cost. Because if one focuses on the nature of the litigation and the interest at stake, and the fact that it is also in their own interest, the mining company, that there should be legal certainty on the question. Even on the question whether or not consent is required for the purposes of their own mining right application, it is in their own interest. So it is true that your leadership exercises their discretion, but in the post-constitutional era, that discretion is constrained by constitutional norms. So it is not clear to us on what justifiable basis the mine can ask that we should pay their costs. So it seems that the correct regime of costs is, if we are successful, we are entitled to recover from the state and the mining company. If we are not successful, the correct order is there should be no order as to cost.
Mr. Spoor.
Oh yes, Mr. Spoor is my attorney. His arguments were made yesterday. Okay. They were responded to yesterday, and they are part and parcel of the record.
Yes. Sorry, did you wish to add anything? Thank you very much for the argument. I will have to take it under advisement. It is a very important case, and I understand it's very important to everyone who is sitting in the gallery, and I assure that I will take my time to consider the arguments properly, and when ready, I will hand down my judgment. Court is adjourned.
Thank you, all of you, to give us support. And the reason that we are here is because of this DMR and the other departments pushing us from the land. Time is over now. And also this court case is not only going to help only the people of Pondoland, it's also going to help all the communities surrounded South Africa, because mining is not only in Pondoland, it's everywhere. And now, if we win this case, even yourself, where you are, where you have contamination of water, you have pollution, now it's time where you're going to give a consent. If you want the mining, you say yes. If you don't want the mining, you say no. Not only the government just decide about us, without us. That time is finished, it's over. It was finished before 1994. Amanda.
Once an Aussie miner camped beside an estuary, under the shade of a milkwood tree, and and the gleam in his eye as he looked upon the mineral sand said, I'll be a mining the wild coast for me. Mining the wild coast, mining the wild coast, I'll be a mining the wild coast for me. And the gleam in his eye as he looked upon the mineral sand said, I'll be a mining the wild coast for me. Down came the media and up jumped the Induna. You'll never take away our land from me. And they sang and they watched and waited till his money spoiled. You won't be mining the wild coast for me. Woodsack Matilda, Woodsack Matilda, you won't be ruining the wild coast with me. And they took that Aussie miner and stuffed them in his tucker bag, so you won't be ruining the wild coast for me. Woodsack Matilda, Woodsack Matilda, you won't be ruining the wild coast for me. So they chased the Aussie miner back to his own bit of land. He won't be ruining the wild coast for me. Won't be ruining the wild coast for me.